A new dawn for artificial intelligence. The EU AI Act. The world stands at the precipice of a new age, an age driven by the transformative power of artificial intelligence. This revolution, like those before it, brings immense promise and potential peril. The European Union, recognizing both, has taken a bold step with the EU AI Act. This landmark legislation seeks to ensure that the development and deployment of AI align with human values, safeguarding our rights and freedoms while fostering innovation. The AI Act is not merely a set of rules but a statement of principle, a commitment to harnessing the power of AI for good. The Act's significance cannot be overstated. It represents the world's first comprehensive attempt to regulate AI, setting a precedent for other nations grappling with this powerful technology. By establishing clear guidelines and obligations, the EU aims to create a predictable and trustworthy environment for AI development, encouraging investment and responsible innovation within its borders. The impact, however, extends far beyond Europe. As a global leader, the EU's actions are likely to influence the trajectory of AI regulation worldwide, shaping the future of this transformative technology. The long arm of regulation. Who does the AI Act apply to? The EU AI Act casts a wide net, encompassing a broad range of actors involved in the AI lifecycle. Its provisions apply not only to developers toiling away at algorithms, but also to those who deploy, use, or even distribute AI systems within the EU. This comprehensive approach ensures accountability across the entire AI supply chain, preventing loopholes and fostering a culture of responsibility. The Act's reach extends beyond the EU's geographical borders. Companies and organizations outside the EU who develop or deploy AI systems whose output is used within the EU also fall under its purview. This extraterritorial application underscores the EU's commitment to protecting its citizens from potential AI harms, regardless of where the technology originates. For AI developers and businesses worldwide, understanding and complying with the AI Act is not merely a matter of legal compliance, but a strategic imperative for accessing the vast European market. Drawing the line: the AI Act's risk-based system. Central to the EU AI Act is a nuanced, risk-based approach. Recognizing that not all AI systems pose equal threats, the Act categorizes them based on their potential to impact fundamental rights, safety, and societal well-being. This tiered system ensures that regulatory scrutiny is proportionate to the level of risk, avoiding stifling innovation while safeguarding against potential harms. The Act identifies 4 distinct risk categories: unacceptable risk, high risk, limited risk, and minimal risk. Each category carries specific obligations and requirements, reflecting the level of potential harm associated with the AI system. Understanding these categories is paramount for AI developers as it determines the regulatory hurdles they must clear and the safeguards they must implement. The Act provides clear definitions and examples for each category, offering guidance on how to assess the risk profile of a particular AI system. Unacceptable risk: AI applications deemed too dangerous. At the apex of the AI Act's risk pyramid lies the category of unacceptable risk. This category encompasses AI systems deemed so fundamentally at odds with European values that they are strictly prohibited. These are technologies considered to pose an unacceptable threat to fundamental rights, safety, or the very fabric of society. Examples of unacceptable risk. AI systems include those designed to manipulate human behavior in ways that could cause physical or psychological harm, such as toys that encourage dangerous behavior in children. Also, banned are systems that enable indiscriminate social scoring by governments, a practice considered antithetical to democratic principles. The Act also prohibits real-time remote biometric identification systems in publicly accessible spaces, except in very limited circumstances, such as searching for a missing child or preventing a terrorist attack. These prohibitions reflect a clear stance. Certain applications of AI are simply off-limits, regardless of their potential benefits. Section 5. Navigating the labyrinth requirements for high-risk AI. The high-risk category encompasses AI systems that, while not outright banned, pose significant potential harm to safety or fundamental rights. These systems are subject to stringent requirements throughout their lifecycle, from development to deployment and beyond. Navigating these requirements is essential for developers seeking to bring high-risk AI systems to the European market. Before a high-risk AI system can be placed on the market, it must undergo a conformity assessment to demonstrate its compliance with the Act's requirements. This assessment includes a thorough evaluation of the system's design, intended purpose, and potential risks. Data quality and governance are paramount concerns, as high-risk AI systems often rely on vast datasets for training and operation. The Act mandates that training data be relevant, representative, and free from bias, mitigating the risk of discriminatory or unfair outcomes. Human oversight is another crucial aspect of high-risk AI, ensuring that humans retain control over critical decisions and can intervene in case of errors or unforeseen consequences. Section 6. Limited risk and minimal risk. A lighter touch. Not all AI systems pose significant risks. The AI Act recognizes this by establishing categories for limited risk and minimal risk AI. These categories are subject to less stringent requirements, allowing for a more proportionate regulatory approach that avoids stifling innovation. Limited risk AI systems, such as chatbots or emotion recognition systems used in specific contexts, primarily face transparency obligations. Users must be clearly informed that they are interacting with an AI system, ensuring informed consent and preventing deception. Deepfakes, AI-generated synthetic media, also fall under this category and must be clearly labeled as such. Minimal-risk AI systems, such as spam filters or recommendation algorithms, are subject to minimal regulation, allowing for their continued development and deployment with minimal bureaucratic hurdles. This tiered approach ensures that regulatory burdens are proportionate to the level of risk posed by the AI system. Section 7. The rise of general-purpose AI obligations and oversight. The AI Act recognizes a new frontier in artificial intelligence general-purpose AI or GPAI. These powerful AI systems trained on massive datasets possess the ability to perform a wide range of tasks and adapt to diverse applications. The Act introduces specific obligations for GPAI developers and deployers, acknowledging the unique challenges posed by these versatile systems. Transparency is paramount for GPAI. Developers must provide comprehensive documentation outlining the system's capabilities, limitations, and potential risks. Information about the training data used, including its source and any steps taken to mitigate bias, must also be disclosed. GPAI systems deemed to pose systemic risks, due to their potential impact on critical infrastructure, public health, or other vital areas, face heightened scrutiny. The Act empowers regulatory bodies to request detailed risk assessments and implement mitigations to address potential harms. Section 8. The price of noncompliance, enforcement and penalties. The EU AI Act is not toothless. To ensure its effectiveness, the Act establishes a robust enforcement mechanism with significant penalties for noncompliance. Member states are responsible for designating national authorities tasked with supervising the implementation of the Act and taking action against violators. Penalties for non-compliance are tiered, reflecting the severity of the infringement. Fines can range up to €35 million or 7% of a company's global annual turnover, whichever is higher. These substantial penalties underscore the seriousness with which the EU views AI regulation and serve as a powerful deterrent against cutting corners or disregarding the Act's provisions. The Act also provides for other enforcement measures, such as orders to rectify non-compliant AI systems, or, in extreme cases, bans on their use within the EU. Section 9. Fostering innovation sandboxes and the future of AI. The EU AI Act is not intended to stifle innovation but to guide it towards a more responsible and human-centric future. The Act recognizes that fostering innovation requires a supportive environment where developers can experiment, test, and refine their creations. To this end, the Act encourages the establishment of regulatory sandboxes. Regulatory sandboxes provide controlled environments where developers can test their AI systems in real-world settings while benefiting from regulatory guidance and support. Within these sandboxes, developers can experiment with different approaches, assess the impact of their creations, and refine their systems to ensure compliance with the Act's requirements. This approach allows for innovation to flourish while mitigating potential risks, striking a balance between progress and responsibility. The EU AI Act represents a pivotal step in the global conversation on AI governance, setting a precedent for other nations navigating the complexities of this transformative technology. As AI continues to evolve at an unprecedented pace, the Act provides a framework for ensuring that its development and deployment align with human values, safeguarding our rights and freedoms, while unlocking the vast potential of this powerful technology.